We're good to go, Mr. Erickson, technology-wise.
Okay, so we're good to go, Julie. You ready? I guess that's a yes. All right. I'm going to call. Yes. Okay. I'm going to call the meeting call to order the Justice Committee. First item on the agenda is roll call. Julie, we take roll call.
Member Schaefer.
Here.
Member Cho.
Present.
Member Smith. Absent. Member Beer.
Present.
Member Martin.
Present.
Member Went.
Present.
Chairman Erickson.
Present. All right. Next item on the agenda is approval of the minutes. Do we have any additions or corrections to the minutes? All right, seeing none, do I need a motion, right? Can I have a motion to approve the minutes? I have a motion by member Chung, a second by member Went. Any comments or discussion? All right, seeing none, let's go ahead and vote. Chairman will be voting.
Thank you. Member Schaefer.
Yes.
Member Chung.
Yes.
Member Smith. Oh, sorry. Member Beer.
Yes.
Member Martin.
Yes.
Member Went.
Yes.
Chairman Erickson.
Yes. All right, next item on the agenda is appearance by members of the public. County Administrator Rodriguez, do we have anybody who wishes to address the committee?
Chairman Erickson, we have three individuals requesting to speak this evening. And I will begin with the first, Dr. Carla Campbell Jackson from the NAACP, and she has joined us by phone. All the speakers understand that I will be timing them for the 5-minute limit. And after Ms. Jackson, Dr. Campbell Jackson is done, then I have two other speakers in person and I will be bringing them forward. So Dr. Campbell Jackson, you have the floor.
And thank you kindly, Ms. Rodriguez. I certainly hope I'm audible.
Yes, you are. We can hear you well.
Excellent, excellent. As the world's oldest, largest, and most respected civil rights organization, the NAACP supports and endorses the tenets associated with House Bill 3653. Prior to the recent onslaught of police brutality against people of color, the Illinois NAACP was on the forefront of policing issues as we have proudly affirmed the 10 shared principles which have been adopted from across our state. Every city from Chicago to East St. Louis has embraced the shared 10 principles. At the end of the day, we want the board to know that we value every life and that we want all people to be treated with dignity and respect. That includes if they're stopped for common traffic violations or for any other issues. Additionally, we endorse the 4 pillars of procedural justice, which are fairness, transparency, the right to having a voice, and impartiality. Please know that the NAACP respects the work enforcement agencies when their acts are conducted decently and in order without regard to race or socioeconomic class. Many members of the NAACP have family members who are diligently serving as members of the law enforcement. I have a cousin who's a captain in the St. Louis area, and I also have a cousin who works in New Orleans as a member of the police team down there. However, we know that racially motivated policing is discriminatory, deplorable, and simply intolerable. The amendment that was brought forth a month and a half ago does not support our aim for justice and equality. As such, the Bloomington Normal branch of the NAACP is recommending that the McLean County Board cease and desist with sharing any misinformation about House Bill 3653. Instead, we must work together to support a bill that is good for our police officers as well as for our citizens. This collaborative effort will help to replace mistrust with mutual trust. Mutual trust is critically important as we all want to work toward a more perfect union. Please feel free to contact the NAACP if interested in further collaborative efforts. And with that, Ms. Camille, I thank you for the opportunity to share.
Thank you, ma'am. Thank you so much. I will now ask Ms. Willie Halbert to come to the podium. I'm going to move aside, and I will be timing Ms. Halbert as well.
Just like to say good evening to everyone. Greetings to the McLean County Justice Committee. My name is Willie Holton Halbert, and I am a 40-year resident of Bloomington Normal and retiree from the Illinois Department of Corrections, where I served as a counselor, a casework supervisor, and assistant superintendent for over 20 years of service. I'm currently running for the Bloomington City Council Ward 3. And one of my main platforms is equity for all. It should be noted, I have a genuine respect for our criminal justice system and our police department. Officers put their lives on the line every day as they protect and serve. My husband, Charles Halbert, served on the Fire and Police Commission for over 12 years, and part of that time was the chairperson. So my support is unquestioned regarding public safety. At the same time, the House Bill 3653 that recently passed only strengthens our criminal justice system and police and provides equity among all people. The tragedies that we witnessed this past summer uncovered major flaws with our system that would allow such inhumane treatment to a person being arrested, and especially as our history has dictated that horror of treatment that has been documented of people of color. It is about justice for all. People from every walk of life gathered right here at our Law and Justice Center this past summer. Black, white, Hispanic, young, old, parents, children, friends, over 1,000 plus to share and demand justice of such horrific injustice we all observe on public TV and reliving through the trial of the officer today. This bill helps to ensure these types of injustice does not continue, but all are held accountable. House Bill 3653, Criminal Justice and Police Reform, was authored by the Illinois Legislative Black Caucus and was approved by the Illinois General Assembly and signed into law by our governor. Unfortunately, there has been so much misinformation regarding this bill that implied that it lessened the authority of our criminal justice system or police departments, spreading the misinformation that the House Bill 3653 ends qualified immunity for law enforcement, all which is not true. The significant changes do in fact deal with police training policies, police accountability, transparency in law enforcement, and the rights of detainees and prisoners as quoted by Senator Sims, who sponsored the bill. Among the changes the bill would bring are the elimination of monetary bail, a requirement that all police officers wear body cameras by 2025, a ban on all police chokeholds, new guidelines for decertification of police officers, and an end to suspended license for failure to pay, among several other changes. In addition to the increase for officers that have known information but afraid to come forward due to retaliation, and add to the right for detainees to make phone calls and access their personal contacts before police questioning. I won't go into all the details because I'm going to leave copies of this report for you to review. In conclusion, The changes in the bill are to assist and to help our police departments, criminal justice system to be more effective and humane in serving all people with respect while still providing and performing their jobs. So the killings, like what happened with George Floyd or Breonna Taylor, would not happen again. To treat every human being with respect while yet protecting our community and helping to keep our officers safe. It has everything to do with basic human rights and equity among all people, regardless of one's economic status. I recommend that the Justice Committee, prior to filing resolutions and pass judgment on a bill, to do due diligence and ensure proper information is being distributed. Respectfully submitted, Willie Holton Halbert. And I do have copies that you can provide to all of you.
I will be happy to do that.
Thank you.
Thank you. Chairman Erickson, we have one more speaker. His name is Zachary Gettridge, and we are going to escort him into the conference room at this time. You're good to start, sir, and I will be timing you.
Okay.
All right, and if you go over 5, I will have to stop you.
All right, I timed it.
Very good.
Thank you, most honorable and esteemed county board members. I am here on behalf of the Solidarity Research Working Group of the Bloomington Normal Socialists. I want to start by thanking the honorable chairperson for bringing the issue of qualified immunity up. I think this is a very important discussion to have. HB 3653 does not get rid of qualified immunity, unfortunately. However, there is a bill in the General Assembly, HB 1727, which would abolish qualified immunity for officers. I wanted to address some spurious comments Mr. Spanos made regarding my comments last month. I had characterized qualified immunity as protecting unreasonable behavior, and Mr. Spanos said that was incorrect. Now, I'm no county country lawyer, so when I made these statements last month, I was actually quoting distinguished law professors Joanna Schwartz and Seth Stoughton. Let's be clear. Derek Chauvin, Alexander Kung, Thomas Lang, Tu Tao, the officers involved in George Floyd's death will most likely receive qualified immunity despite international condemnation, including from law enforcement and many conservatives. Jonathan Mattingly, Brett Hankinson, Miles Cosgrove, the officers who murdered Breonna Taylor while she was sleeping in her bed will get qualified immunity. Nathan Woodyard, Jason Rosenblatt, and Randy Rodema, the officers that murdered Elijah McClain, will also likely receive qualified immunity. Mr. Spanos, if you believe these cases are reasonable mistakes, then your definition is most unreasonable. Under qualified immunity, government workers can only be held accountable for violating someone's rights if a court has previously ruled that it was clearly established these precise actions were unconstitutional. If no such decision exists, the official is immune, even if the official intentionally, maliciously, or unreasonably violated the law or constitution. The primary consideration in qualified immunity analysis is whether there is an earlier court case specifically stating that the particular actions of an official are unconstitutional. For example, the U.S. Court of Appeals recently held that a prison guard who pepper sprayed an inmate in his locked cell for no reason did not violate a clearly established right because a similar cited case involving a law enforcement official who tased an inmate for no reason rather than pepper spraying them for no reason. A police officer shot a 10-year-old child while trying to shoot a non-threatening family dog. The Court of Appeals held that the officer was entitled to qualified immunity because no earlier case held it was unconstitutional for a police officer to recklessly fire his gun into a group of children without justification. Qualified immunity applies even when officials intentionally or recklessly violate the law. Again, the U.S. Court of Appeals held that police accused of stealing $225,000 while executing a search warrant were entitled to qualified immunity because the court had never addressed whether the theft of property covered by the terms of a search warrant violates the Fourth Amendment. It did not matter that virtually every human society teaches that theft generally is wrong. Again, Mr. Spanos, if this is your definition of reasonable, I don't even want to know what you consider unreasonable. Even if qualified immunity for officers were abolished, they still wouldn't pay a dime because they are indemnified by the county for all actions, and the county has a duty to defend said officers if they are sued. This is all in the union contracts, and I encourage you all to look it up. Beyond qualified immunity, I do want to address what has been going on in the jail. Until the last week or two, all inmates were kept under solitary confinement for months. This is the sheriff's primary COVID mitigation strategy. The United Nations rules on imprisonment, called the Mandela Rule, state any solitary confinement longer than 15 days is cruel and unusual. McLean County inmates were in solitary for over 120 days. This is despite the fact inmates were eligible for COVID vaccines as early as January, according to the State Health Department, and in direct contradiction from the sheriff's previous statements to this board. I've spoken to other sheriffs who were aghast that our most perfidious sheriff would implement such a harsh policy for this long. In early November, the sheriff had all inmate windows covered up, preventing them from seeing out, and I can only assume preventing very little light from entering. I would be interested to know if there were any vitamin D deficiencies this past winter, which would have increased the mental trauma they experienced. Besides multiple requests to county board members, I still can't get an answer on how much this cost or how it was paid for. I'm not exactly sure why this is so difficult for some of y'all to ask this question. Thank you and have a good day.
Thank you. Chairman Erickson, that concludes our public speakers for this evening. Thank you.
County Administrator Rodriguez, I want to ask you a question. I know one of the speakers said they were going to leave some material. I thought they said that. If that's true, can we make sure everybody on the Justice Committee gets it? Is that what they said they were going to do?
They, yes, sir. They handed that information to me, and so I will certainly scan it and send it to the committee following the meeting.
Okay, thank you.
Thank you.
All right, the next item on the agenda is item 4 matters. The first item is item 4A, Kathy Yoder, McLean County Coroner. There are no items for action, but she has submitted her monthly report. Kathy, are you there?
Yes, I'm here, Chuck.
Yeah, do you have any comments or anything you want to say about your report?
No, it's pretty standard. Thank you.
Does anybody have any questions of the county coroner? All right, seeing none, thank you, Kathy. Next item on the agenda is item 4B, Don Knapp, McLean County State's Attorney. We have no items for action, but he has presented his report. Don, do you have anything that you'd like to say about your report?
No, I think it's pretty early every time we get, a few months in to try and draw too many correlations for trends. I think you'll notice that DUIs are up compared to last year, but the 730 projection is about where we are at in a non-COVID year. And we've talked about ad nauseum last year that we were down about a third of DUIs due to the bars being shut down and less people driving. But other than that, numbers seem to be trending about where they usually are this time of year.
Does any member have?
Chuck, you muted yourself.
Quiet. Next item on the agenda is item 4C. Mike Donovan, Director of Court Services. Item 4A, request approval of a memorandum of understanding with the YWCA McLean County. Can I have a motion to approve? I have a motion by member Went, a second by member Chung. Mr. Donovan, would you like to discuss that?
Yes, sir. Thank you. The YWCA contacted me about signing an MOU between us and them as part of a grant they were seeking. Didn't have time to get it submitted prior to the grant, so we submitted another version of it, which is just a general MOU for referrals from us for their Labyrinth House program, and that's what you have in front of you.
All right. Do any of the members have any questions for Mr. Donovan? Member Schaefer.
Is it a grant for us or is it a grant for them?
It was originally requested as a grant for them. They requested the MOU, but didn't realize that it would have to go through the county board cycle. So the grant's already been applied for. So they still wanted an MOU just as an understanding with us to submit referrals.
Any other questions? Any comments? All right, seeing none, let's go ahead and vote. The chairman will be voting.
Member Schaefer,
Yes.
Member Chung,
Yes.
Member Beer,
Yes.
Member Martin,
Yes.
Member Went,
Yes.
Chairman Erickson.
Yes. All right, thank you. Next item on the agenda is item 4D. Don Everhart, McLean County Circuit Clerk. We have no items for action, but he has presented his report. Don, would you like to discuss that?
There's nothing unusual about the report to bring to the attention, so no.
All right, that's fine. I just want to know if you have something you want to say in particular about it. All right, does any member have any questions of the Circuit Clerk? All right, seeing none. Thank you, Don.
Thank you. Have a good evening.
You too. All right, next item on the agenda is item 4E, the Public Defender. We have no items for action, but we do have a caseload report. Is that Mr. Lewis in the background?
Yes. Yes.
All right, I just want to say congratulations, Mr. Lewis, on your appointment as the Public Defender. So make sure we say that to you first. So congratulations. And do you have anything you want to say about your report?
Mr. McEldowney is here with the report, and I wanted to say hello to everyone as the new public defender to fill the vacuum that left by Carla Barnes when she became a judge. The appointment will take effect on Monday. I wanted to thank Mr. McEldowney for his service as interim public defender, and looking forward to not only the professional representation of our clients, but the continued collaboration with all the other justice stakeholders. I've been here for 25 years, and we've got a really good collaboration set up, and I'm looking forward to that and looking forward to serving in this position. And we'll leave it to Mr. McEldowney for the report.
Mr. McEldowney, do you have any comments you'd like to report?
I would agree with what Mr. Knapp said. I think the numbers are kind of self-explanatory, and there's some fluctuation, but over the course of time, I'm sure they'll even out. But other than that, I don't think I have anything else to say.
All right. Do any of the members have any questions of Mr. Lewis or Mr. McEldowney? All right, seeing none, thank you. Thank you. All right, next item on the agenda is item 4F1A, request approval of an emergency appropriation ordinance amending the McLean County fiscal year 2021 combined annual appropriation and budget ordinance. And can I have a motion? I have a motion by member Martin, a second by member Schaefer. Miss Evans, would you like to discuss that? Have any comments?
Sure. This is just a combination of multiple local, state, and federal grants that we have received. All of the grants that are, or the new revenue that is listed here, all of those have gone before either this committee or the committee last year. We got a couple of the grants right in October of 2020. So just adding that revenue into 2021.
Any questions of Miss Evans? All right, seeing none, let's go ahead and vote, and the chairman will be voting.
Member Schaefer,
Yes.
Member Chung,
Yes.
Member Beer,
Yes.
Member Martin,
Yes.
Member Went,
Yes.
Chairman Erickson.
Yes. Thank you. Thank you, Ms. Evans. Next item is our monthly statistics and general report. Do you have anything you'd like to add about that?
I don't. I'd be happy to answer any questions that you might have. Though I would like to add that April is Child Abuse Awareness Month. So at the Children's Advocacy Center, we try to partner with other community agencies just to raise awareness and promote prevention for child abuse. So if you drive by the downtown area, you'll see on the southwest corner of the old courthouse or the museum, there's blue pinwheels that have been planted there. CAC staff have also planted pinwheels in our sites in Livingston and DeWitt County. And we're just doing what we can, offering trainings, spending some more time with our MDT partners, and also offering some community trainings this month in efforts to prevent child abuse.
Any members have any questions? All right, seeing none, thank you, Ms. Evans.
Thank you all. Have a good evening.
All right, the next item on the agenda is item 4G, the McLean County Sheriff. We know we have no items for action, but we do have the monthly statistical report. I see that County Administrator Rodriguez has approached the podium. What would you like to say? Go ahead.
Oh, Chairman Erickson, I only wanted to note that our sheriff was unable to attend the meeting this evening. I could attempt to answer questions of the membership, but also log those questions and have the sheriff get back to you at another time.
Does anybody have any questions they'd like passed along? Member Chung.
Yes, thank you, Chairman Erickson. I guess I asked this a little bit last night in our health committee meeting about the vaccines that are given to the inmates. And I guess I was kind of looking forward to asking the sheriff about it today. But I was just wondering, there's sort of plans that they're going to be doing another sort of vaccine clinic. And what they're trying to do to get the sort of interest or number of inmates signed up to get vaccines, what they're going to try to do to help that out some more. But I don't know, I guess that was my question. So you knew that probably already from yesterday, Ms. Rodriguez. So I guess that was my main question I was going to ask him. And I guess I was also curious about, I guess I had been kind of asking him about this in the past couple months about the solitary confinement and locking down the prison to 23 hours a day. And I was and I read an article saying that he had been, I guess maybe allowing some people to gather in some spaces. So I was just kind of wondering about what that was and just kind of getting a better idea of how that was working out. So that was my other question for him, but I guess if you could pass that along to him, that would be great. Thank you.
We'll pass both along. Thank you.
Does anybody else have any questions? All right, seeing none. The next item on the agenda is item 4H of the county administrator. We have no items for action. Do you have anything you'd like to add? No. County Administrator Rodriguez.
Oh, no, I don't, Chairman Erickson. Thank you.
All right. Next item on the agenda is item 5A1, State's Attorney presentation on tort immunity. This is an item presented for information. Is Mr. Spanos here? I see you, Member Chung. Wait a second. I'll get you. Okay. You here, Chris?
Yes, sir.
Okay, I saw that Member Chung had raised her hand. I want to make sure I use proper grammar here. So, Member Chung.
Thank you, Mr. Chairman. I guess number one, thank you for putting this on the agenda. I guess I'm assuming that it was because I raised a little bit of a stink about it last month. So thank you for doing that. But I guess today I might just have to also register my sort of, confusion or just the relevancy of this presentation today. As we all know, and was sort of brought up last month in the number of public comments that we'd heard, that qualified immunity is not an issue that's in this bill that had just been passed in the Illinois General Assembly. So I'm honestly kind of unsure why we're discussing it today when it's, yes, there is a bill that's kind of, possibly in the wings, but I don't really understand why we're doing this today, because number one, I think it's in sort of poor taste in the fact that right now this very public trial is going on with Derek Chauvin trial right now in Minnesota, and that we're talking about this when this is a very sort of heated topic in the nation, on the nation right now, and for us to be discussing this, I guess to me it just seems in poor taste. And the other thing that I want to say is that today is also our municipal election day, and to be using this time, I mean, I don't mind that we're in a meeting where we're talking about the things that are relevant to our county business right now, but I'm sure that at least for me and some other people, I think we would be happy to be going out and making sure that people are getting to the polls before 7 p.m. and helping out our preferred candidates. So I just wanted to register that. I don't know if that changes anything with Mr. Spanos, but I just wanted to get that on the record. So thank you.
Thank you, Member Chung. Does anybody else have anything they want to say? I'm going to address some of that, but does anybody else have anything they'd like to say? Okay, what had happened was, I just want everybody to know, is that it was a bipartisan idea that someone came to me. It was more than just a Republican. And they came to me and they said, Chuck, we've got questions about qualified immunity. We've got questions about tort immunity. And we would appreciate it if you would at least have the state's attorney give an explanation about it before you did anything further on it. And so with that suggestion made to me, I had asked the state's attorney if they would be willing to do a presentation on tort immunity. And I did run this by Mr. Spanos and I did run this by Mr. Knapp, and I asked how they wanted to do it. And they said they would be happy to do a presentation on tort immunity. So the reason it is on the agenda is because Republicans and Democrats, and there were Democrats that had asked me to address the subject. I do want to add that yesterday I received a phone call, and it was from a member on the other side of the aisle from me, and she had questions about it as well, and I spoke to her for about 10 to 15 minutes, and I don't know if I answered all her concerns, all her questions, but I did try to explain why I was putting this as an item for information. In particular, the questions that I had largely got, it centered about where was the legislature on this, what is tort immunity, and what's the impact of it. And so I passed those along to Mr. Spanos presentation on it. And President, Mr. Spanos, are you ready?
I am. I'll start out by saying there's no tilde over the end. It's just a straight Spanos. But I can answer to just about anything. So if we could have IT allow me to share my screen, I prepared at your request a PowerPoint that I'd like to go through. All right.
It'd be good now, Chris.
Thank you, Craig. Let's see, slideshow. I don't do this very often, so present online. Isn't that what I'm doing? Here we go. That's all. I just want to present it from the beginning. Here we go. There we go. Okay, so I was asked to give a summary of the status of the law in Illinois on qualified tort immunity. So what I did and what you will see are going to be almost exclusively screenshots or excerpts rather from actual law. There's a few case quotations. When we get to the Illinois Tort Immunity Act, you will see that it is exclusively from the statute itself. I have at the end also included 2 references to the House bill that was recently signed with an exact quotation of what's in that bill. with respect to qualified immunity, at least partly, and then with the new House bill that is also currently pending. So with that being said, and that apparently means the clothes are ready in the dryer. So, can everybody hear me okay? Anybody hear me?
Yeah, we're hearing you okay in the government center.
Excellent. Okay. So the federal law, there's two sides to qualified immunity. There's federal law and the state law. We'll go through the federal law first. Civil Rights Act of 1871 established a civil cause against any person acting under color of state law or color of law. It's a phrase that persists and is common in 1983 actions we'll talk about here in a minute. Right now, Section 1983 may be implicated when a law enforcement officer makes an arrest, uses force, or conducts a search. Over time, that has changed, but what I wanted to make sure you understood was that the 1983 refers specifically to civil action for deprivation of rights. It has nothing, it is inapplicable to any criminal action. And there you can see the statute itself, or at least that portion of it. Under color of state law, again, any statute, ordinance, regulation, custom, or usage, and that person shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. And this is from the United States Supreme Court. This is a direct quote from the cases. I believe this says that local government officials, I guess it's a summary of the case, could be sued individually under Section 1983 as acting under color of state law, and that's as of 1961. Come on, there we go. And that in federal liability, the Section 1983 applies to civil actions against individual officials or employees, but not against the governmental entity. So it can bring a 1983 action against the county itself. In 1967, the doctrine of qualified immunity was established by the United States Supreme Court in Pearson versus Ray, where police officers were granted qualified immunity for an arrest that was executed in good faith with probable cause under a statute that the officers believed to be valid at the time. So later, through the case law, it became reasonably believed to be valid. And there's a little bit more in this here in a second. Come on. So the difference between qualified and absolute immunity, just to make it clear, absolute immunity offers stronger protections, but is rarely applicable. There are very, very few instances, although you as a county board in your legislative capacity have absolute immunity. Qualified immunity, which simply means the immunity is qualified, there are restrictions on it, offers weaker protection, but no more government officials. Simply means not absolute. And then in each case, the restrictions are a bit different. So qualified immunity only shields an administrative officer from liability if the officer's activities are within the scope of his or her office, are in objective good faith, and by objective means judged by the standard of the average ordinary person, as opposed to subjective, which would mean judged by the standard of that individual's discretion, and that they do not violate clearly established statutory or constitutional rights, which a reasonable person would be aware of. So in 1982, Harlow versus Fitzgerald is kind of a seminal case. It found, and there you see their quotations, that government officials that are acting in their professional or their official capacity are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights, which a reasonable person would have known. It goes on, if the law at that time was not clearly established, an official could not be expected to anticipate subsequent legal developments, nor could he fairly be said to know that the law forbade the conduct not previously identified as unlawful. So in Harlow versus Fitzgerald, they decided that bare allegations of malice would not subject government officials to the cost and burdens of trials and broad-reaching discovery. They held that government officials performing discretionary functions generally are shielded from liability for civil damages. And again, insofar as their conduct does not violate clearly established statutory or constitutional rights, which a reasonable person would have known. The reason cited in Harlow for this immunity is to minimize the expense of litigation of bare allegations of malice by allowing an earlier dismissal, avoid diverting energy and resources from essential governmental functions due to litigation over, again, bare allegations of malice, avoid the deterrent effect of potential liability for qualified individuals seeking to serve the public, and avoid the chilling effect of liability on officials in the unflinching discharge of their duties. That's their words. In Pearson versus Callahan in 2009, the United States Supreme Court said again that qualified immunity protects government officials from liability for civil damages. Qualified immunity balances two important interests: the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. The protection of qualified immunity applies regardless of mistake of law, mistake of fact, or mistake based on mixed questions of law and fact, as long as the mistake is reasonable. So now we move to the Illinois Tort Immunity Act. Back in 1898, the Illinois Supreme Court held that governmental entities enjoyed absolute immunity, and that was the law until 1959, when the Illinois Supreme Court found that not to be the case. And then the legislature stepped in and again granted by statute complete or absolute immunity to counties and park districts, and partial immunity to schools. But then again, that didn't stand. And in 1964, the Illinois Supreme Court held that statutory scheme was unconstitutional. So in 1965, they enacted the Local Government and Governmental Employees Tort Immunity Act. And that is the statute that's currently on the books in Illinois. It has been amended and changed over the years, but it still stands for the same, essentially the same proposition. Now I'll go through some of the terms. These are all statutory citations. This is cut and paste from the official website of the state government. These words are theirs, not mine. Of course, I'm highlighting those issues that I thought you would find important. The purpose of the act is to protect local public entities and public employees from liability arising from the operation of government. Grants only immunities and defenses. So I put in a definition for tort. I don't know if I really knew what tort meant before I went to law school, but it's a wrongful act or an infringement of a right of other than under contract. So it's not a contract right, leading to civil legal liability. So the Tort Immunity Act only applies to civil legal liability. And there's 100 other places where you can find a very similar decision. Injury. The statute describes an injury or defines an injury as death, injury to person, or damage or loss of property. But then it goes on and indicates injury includes any injury alleged in a civil action. So local public entity includes a county. And then section 1-207 includes public employee. Any public employee means an employee of a local public entity. There's also, this is a key definition, and this slide will come back up again here in a minute. But willful and wanton conduct, as you will see, is the exception to qualify or liability, immunity under the State Tort Immunity Act. If a person, an employee of the state, the county, who otherwise would enjoy immunity under the act, if that person's actions are willful and wanton, which means actual or deliberate intention to cause harm, or which show an utter indifference to or conscious disregard for the safety of others, immunity does not apply under the current statutory scheme. Nothing in the act affects the right to obtain relief other than damages, and remember, damages are civil, against a local public entity or public employee. This is a local public entity is not liable for an injury resulting from an act or omission of its employee where the employee is not liable. This is important for respondeat superior or derivative liability, where an employer is typically responsible for the liability of its agents or employees. A public employee is not liable for his act or omission unless it's willful and wanton. Okay, let's go back through this because there's another important phrase here. In the execution or enforcement of any law, and I'll just tell you without getting into the substance of any of those cases with you, there are a multitude of cases in Illinois that address the issue of what it means to be in the execution or enforcement of any law. And the outcomes are varied. Sometimes it's found to be, and other times it's not. If a public employee acts in good faith, without malice, and under the apparent authority of an enactment that is unconstitutional, invalid, or inapplicable, he is not liable for any injury caused thereby, except to the extent that he would have been liable had the enactment been constitutional, valid, and applicable. And this is one that I know gives rise to some controversy. If you were asking me to interpret this for you, what I would say is that if the law had been constitutional, valid, and applicable, and the employee reasonably knew or should have known of it, he would be liable. So here we are back with the willful and wanton conduct is used in the act. Again, actual and deliberate. Let me go back for just a second. I think I stuck that in the wrong place. There we go. A public employee is not liable for an injury arising out of his entry upon any property where such entry is expressly or impliedly authorized by law. Nothing in this part 3 relieves a local public entity. Remember, local public entity includes the county of its duty to indemnify or insure its employees as provided in, and the section that matters for us is section 5-1002 of the county's code, which says indemnity of sheriff or deputy. If any injury to the person or property of another is caused by a sheriff or any deputy sheriff, while the sheriff or deputy is engaged in the performance of his or her duties, the county shall indemnify the sheriff or the deputy for any judgment recovered against him or her as a result of that injury. Remember, again, injury is civil, except where the injury results from the willful misconduct of the sheriff or deputy. You see there, the limit of the county's liability by statute is up to $1 million. And remember, I guess to read these together, I'll remind you that a prior section of the statute said that the county is not liable if the deputy or the employee is not liable. This statute provides that the county is liable if the deputy is liable. It does not provide for defense of a criminal action. It specifically excludes that unless the criminal action is dismissed or results in a final disposition in favor of the employee. Then the county may reimburse the employee for reasonable defense costs, including attorney's fees. But if a deputy is charged with a criminal act, the county is not required, in fact, is not allowed to reimburse or represent that deputy. Now, the question is whether or not House Bill 3653 has anything to do with qualified immunity. This is a section out of the statute that was signed into law. It created this task force on constitutional rights and remedies, which is charged with the duty of to develop and propose policies and procedures to review and reform constitutional rights and remedies, including qualified immunity for police officers or peace officers, excuse me. So that's the bill that was already signed into law. This is the bill that's pending now, the new bill, House Bill 1727. And this is the summary. I didn't want to put the whole thing out in front of you. You can read it if you'd like. It provides that qualified immunity is not a defense to liability under this provision. Another thing that would be relevant to the county, important to the county to know, and the county board, is that it expands the statute of limitations, the period for which to claim 5 years from 2 years. So that's all that I have. I'd be glad to answer any questions. I have to give you back my screen, don't I?
Yeah, if you just stop doing the screen share, you'll be all set.
Yeah, I got to figure out where to do that. I don't.
Right next to microphone, camera, and then you'll see a screen button.
I'm not seeing that right now. Oh, here it is. I got it. Yep. There we go. Okay.
Does anybody have any questions? Chris, can you make your presentation available to the members of the committee too?
Sure, absolutely.
And I also believe that there was a representative from the NAACP. If she had anything that she had wanted to leave with the committee, I would ask her to leave that with County Administrator Rodriguez so we can take a look at that as well. All right. Seeing no questions or comments, I'm looking. I don't see any. I'm going to move on to the next agenda item. That is recommend payment, item 6. It's item 6. Recommend payment of bills and transfers, if any, to the county board. I have a letter here from the McLean County auditor recommending the bills. County Administrator Rodriguez, can I do this as all as one? Or do I need to do the bills and transfers separately?
Generally, we do them separately, sir.
Okay. All right. We'll do the bills first. All right. A motion to approve the bills. I have a motion by Member Martin, a second by Member Chung. Any comments or questions? All right. Hearing none, then let's go ahead and vote, and the chairman will vote.
Member Schaefer?
Yes.
Member Chung?
Yes.
Yes. Member Beer?
Yes.
Yes. Member Martin?
Yeah.
Member Wendt?
Yeah.
Yeah. Chairman Erickson.
Yes. All right, we got an echo through there. Okay. Next item on the agenda is transfers, and that's item 6. We take the transfers all as one. You think I'd know this by now, County Administrator Rodriguez, but we can take them all as one, right?
If it pleases the committee, sir, yes, you should.
All right, let's take the transfers all as one unless someone has an objection. All right, seeing none, can I have a motion to approve the transfers? I got a motion by member Went, a second by member Chung. Any comments or questions? All right, seeing none, let's go ahead and vote, and the chairman will vote.
Member Schaefer.
Yes.
Member Chung.
Yes.
Member Beer.
Yes.
Member Martin.
Yeah.
Member Went.
Yes.
Chairman Erickson.
Yes. All right, that's everything. We've got one last item, adjournment. Thanks for coming. It's good to see everybody. We'll see you next month.